All right, thank you everyone for joining today, and for all those watching this recording. So welcome to the CD Howe Institute's webinar on competition policy. The question today is why Canadians should pay attention to the competition policy review, which we're going to get into in more detail. But first, a few bits of housekeeping. I'm Ben Dachis. I'm Associate Vice President of Public Affairs at the CD Howe Institute. And as part of all of our events, our notes for the host say, I'm supposed to say that the CD Howe Institute is great and is a charity. And that's really easy for me to get into because both things happen to be true. We at the CD Howe Institute have been working on competition policy for over 10 years with our Competition Policy Council, of which we have 3 members here today. And we're also a charity. Being a charity, we're able to do these events and operate a council like this thanks to the support of our many members. So thank you all for taking part today and for your support of the CD Howe Institute. So this webinar is going to be recorded and will be on the CD Howe Institute website and shared with all of our constituents at some point during the winter and spring. So with no further ado, it's my great honor to introduce 3 members of our Competition Policy Council. The Institute's Competition Policy Council comprises of top-ranked academics and practitioners who are active in the field of competition law and policy. The Council provides analysis of emerging competition policy issues, and no issue is more important in this field right now than the federal review. I've had the honor of being able to sit in for most of the 20-plus meetings of this Council, and it is amazing the intellectual horsepower that we have around that table. I learned so much from this group, and it's just an honor to be able to host this group since its inception over 10 years ago. So our panel today, I'll start with Melanie Aitken, who's a managing principal at Bennett Jones. Melanie carries on her practice of Canadian law in DC, Washington, DC, in association with Bennett Jones LLP. She's also co-head of the Competition and Foreign Investment Practice of Bennett Jones. She served as Canada's Competition Commissioner in charge of the Canadian Competition Bureau from 2009 to 2012, having previously served as the Senior Deputy Commissioner leading merger review from 2006 to 2009. We also have Elisa Kearney, partner at Davies, Ward, Phillips, and Vineberg LLP. She has a broad regulatory practice with a specialization in competition and foreign investment law. She has vast knowledge of Canada's regulatory framework and provides strategic advice on numerous federal statutes to domestic and international clients. She regularly appears before the Competition Bureau and has acted as external counsel to the Commissioner of Competition and the CRTC. And just as importantly to us here at the CD Howe Institute, she's the chair of our Competition Policy Council. And John Pecman, he was a senior business advisor at Fasken, and he's in the Competition, Marketing, and Foreign Investment group there. He's an economist with an MA from McMaster University, and he worked at the Competition Bureau as an investigator, manager, and executive for more than 34 years. And he served as the Commissioner of Competition at the Bureau from June 2013 for a 5-year term. He's a senior fellow at the CD Howe Institute, as well as the TMX Industry Professor at the Groot Business School at McMaster. So let's get right into it. And what we're going to do today, I'm going to ask some questions to start things off, going around the panelists today, and we'll take questions from the audience as they come in. So let's start with a topic that we posed at the very start of this. Why should Canadians pay attention to the competition policy review? Elisa, why don't we start with you?
Sure. Thank you, Ben, for inviting me to join this panel. It's a real pleasure to be here with Melanie and John, very skilled insiders who no doubt everyone is very keen to hear from. I thought I'd just mention my perspective while I'm here on this panel. So I've been listening as chair of the Competition Policy Council and an active member of the Canadian Bar Association to the views of our members for the last number of years. And the views are extremely diverse. There's no single voice amongst the practitioners or academics and economists that both CD Howe and the CBA support. But as chair, I'm often act as a moderator, facilitator. I'm used there to try to find a consensus or a middle ground. So I think in some of my comments today, I'd like to try to convey that. What we're hearing from active members of CD Howe and the bar. So let me see if I can tackle your question, which is, why should Canadians be paying attention to the competition policy review? And I think it's really to give the government the opportunity to get it right and to make reforms that are both effective and meaningful. So listening to consumer groups and small businesses, they'll be able to provide real life examples of perceived harm. Listening to other businesses who may tout their innovation, their success, and the opportunity that Canada and the Canadian economy gives to them. To think tanks who will be pushing the boundaries of the debate, and to the lawyers who will find flaws, they'll identify weaknesses, they'll look for loopholes, and they'll probably try to rein in a little bit of what's being heard. So for this to be effective for Canadians, I think the government needs to listen openly and genuinely and engage with all of the viewpoints that will be expressed over the course of the coming few months.
Perfect. Melanie, John, anything to add in terms of the importance of this review?
Well, if I can chime in, again, thank you for the invitation, Ben. CD Howe Institute has been a fabulous forum for thought leadership in many policy areas. The Competition Policy Group has many of my former commissioners, a lot of inside information, knowledge, and the information that is shared and imparted with the public, I think is extremely valuable with all the insights that the members provide. So again, thanks for the invite. And I do want to make a disclaimer before I comment at all. The fact that my views are my personal views, shaped by 34 and a half years of enforcement experience at the Competition Bureau, amongst other experiences I've had in competition law and policy. They're not the views of Fasken, its clients, or even the Chamber of Commerce, where I just recently wrote a report for them on competition policy reform, which I commend you all to. So these are my views. I just want to emphasize that, and it gives me a lot of latitude in terms of my commentary, given everyone's interests in this debate. So with respect to the importance of the current process, clearly competition policy and law has come into the spotlight with concerns about market concentration, high prices, and it's been a while since we've had a deep dive into the law to see if it's still effective in our digital economy. So I think it's really important for us to take a look. There is concerns about how protected competition is in Canada. And again, this might be an opportunity to break open some of the log jams and improve competitiveness in our country. And so I think, this debate's important. I think the policy process we're going through now is as well. And I'm looking forward to strengthening competition law and policy in our country. I think it'll benefit us all.
Very good. So I guess I'll turn to a specific example of something that's part of this review. And it's questions that we're hearing about sector-specific legislation and rules that need to be put in place for data and digital markets. How do you, John, how do you see this review tackling that question?
Yeah, and again, the part of the impetus was the rapid rise of big tech and the concerns and the reviews that have been done on digital competition by government and experts around the world, which have supported a much more active approach to antitrust enforcement and even regulations, as we see in Europe with the Digital Markets Act recently being passed. So there have been allegations of vertical discrimination conducted by big tech companies and have led to many successful court cases in the EU, for example, cases with Google, for example, and others. Yet, the EU's turn to targeted ex-ante regulations with the risk of harming innovation. As we all know, regulations can harm innovation and consumer welfare in order to promote more contestability and to replace the sluggish processes of investigation and adjudication in a dynamic market and rely more on efficient prohibitions. And again, it's something you shouldn't rush to, I think, as policymakers. I've seen studies that suggest that this move to a more regulated sector environment could cost the EU economy up to 85 billion euros of GDP because of the harm to again competition and some of the things it brings by creating this regulatory approach, which again most competition authorities advocate against using. The US is also looking at an ex-ante approach to regulations for digital platforms, but I think it seems unlikely that these current bills will be ratified by Congress or the Senate, and I think wisely in my view. And in Europe, of course, in Britain, we're seeing the implementation of a code of conduct to regulate large digital platforms, the competition aspects of it. So understandably, Canadian policymakers and advisors have been following this debate and developments abroad and considering both those issues in the current ICED consultation paper. It's needs to be looked at closely, I would suggest. And regulations can be helpful to society and the economy where there is market failure. The question I always ask myself is digital platforms, social media, e-commerce, should they be treated as public utilities as an appropriate policy response where traditional antitrust tools have been successful in tackling alleged anti-competitive conduct by these digital firms? The Competition Bureau itself is not asking for big tech ex-ante regulations in this debate. They've come out and given some views. They know what the cost of regulations would be to the economy in terms of harm to innovation and consumer welfare. And they support the traditional approach of economic analysis combined with evidence of harm for digital markets, which have been the cornerstone principle for competition law enforcement internationally for over 40 years. And to switch to a regulated environment where competition laws can work, I think having better tools for the Bureau to conduct speedier investigations and arrive at quicker adjudication through streamlined injunction processes, or looking at things such as final offer arbitration that's used at the CRTC for their vertical code of conduct, might be the better approach in my view, without looking at costly regulation and that whole process. So those are just some of my initial thoughts on this issue, but I'm sure others have different points of view as well.
Yeah. Melanie, Lisa, anything on the question of data and digital markets and sector-specific regulation?
Go ahead, Melanie. Is there anything you want to add?
Yeah, I think, so first of all, I want to say hello and thank you to CD Howe for inviting me to this panel. It's always a pleasure to chat about these issues, and certainly with John and Elisa and Ben. I think on that, I guess I'm not as optimistic about, sort of what the Bureau thinks they want when I read what they're best for and when I read the consultation paper, which admittedly are two very different ships. But, an easier standard, as I may comment on later, I don't think is an answer to anything. As a former commissioner, generally, John put it well, generally very antagonistic to regulation, given the cost that has and the uncompetitive and the, perhaps sometimes unintended, but very negative effects on R&D, innovation, and productivity, but also acknowledging there are public policy issues that are far beyond the scheme of competition that can absolutely justify regulation at the right time. And even apart from those, there can be market failure, but it have to be pretty sure there's market failure before it is a good thing for Canadians, I think, for us to step in with regulation. And so a word of caution, not to do anything, but certainly caution about departing from our tradition of requiring cases to be made out and heading to some kind of per se rule when, as John pointed out, we're already hearing some pretty bad predictions about how that's going to go. We all know Europeans have a much greater tolerance for regulation and the consequences that come to that for standard of living and the health of your markets. So my word of caution is, really just pause before you think about regulating, and pause hard. There are other things we can do. I don't think this act has really been shown to be problematic per se. I think there are other things that we can do to enhance enforcement in Canada, which I unequivocally believe we need to do.
Perfect.
And yeah, if I can just I was thinking about this a little bit differently, because I agree 100% with the comments on ex-ante regulation and the cost of regulation, and I think the government itself recognizes a red tape that exists throughout the Canadian economy and a desire not to do so. But I think the question sort of data and digital markets and this review There's a sort of overarching issue that sometimes gets spoken about and sometimes doesn't. And that's the recognition that data is the currency in these digital markets. And so when we're looking at this marketplace framework and they're trying to set the rules of how this marketplace is going to work, I think the question when we're asking if the act is fit for purpose, it's, is the act as it exists today sufficient to govern these mega players, to use the language from the consultation, by the same rules of the marketplace, or whether there needs to be a specific set of rules, particularly taking into account, data as that currency. And one thing I think we need to also consider is the availability of appropriate remedies. So if we're looking at whether the act itself will address some sort of conduct by these mega players, we also have to consider, is there a remedy that's appropriate for the solution? And I think that's where we get into other rules and statutes and needing to make sure we have a semblance of coherence. So, for example, data remedies intersect with the data governance in their interoperability and portability. But then that goes to, well, who owns the data if there's going to be a data remedy ordered, and is consent required, and how can consent be given? And so that's where you see sort of data governance statutes not intersecting with competition law at all, but hitting on it. And so I think in addition to this discussion about whether we need ex ante rules governing the platform, I think we also need to, make sure we're considering how potential future remedies in the marketplace, our existing Competition Act, modified as it may be, how that will impact and play in the digital markets and the new rules that are coming into place around governance and privacy.
There's a lot to unpack in that that we'll get to during the session. But just as a reminder for people who just joined, we're going to be asking the panel a series of questions throughout today. And if you do have a question, put it in as soon as you can, as we want to get to as many of your questions as possible. The way to do that is that you have a Q&A box at the bottom right-hand corner. If you can't see it, there should be a button for it. So please do type in your question in that, and I will make sure to get to it. Another reminder, this is being recorded for us to post on our website afterwards. So we talked a little bit about the Bureau's powers, but now we're getting into a world where the Competition Bureau and the ISID paper are asking for an enhancement of powers. So what kind of powers do you think the Bureau should have that are different from today? And I guess a follow-on question is, what kind of oversight needs to come from Parliament if it is to get some of those expanded powers? So we got a bunch of former commissioners here, so maybe we'll start with one of them in terms of if they were a bureau head, what would they want, at least in that world, but also the lens of being from on the outside now. So maybe we'll start with Melanie on this.
Sure, thanks, Ben. I guess I'd start with a sort of a similar takeoff point as John. These are my views, and honestly, they haven't changed depending on which hat I'm wearing. I actually am not afraid of saying things that whatever constituency I'm representing at the time might find problematic superficially, because I actually think that I may be right or may be wrong and where I draw the line, but I do believe that good, competitive, strong markets are good for, yes, Canadians, but they're also good for big business. It's not good to not have rules, just like little children. People like rules, people behave better, and people conduct themselves better when there are rules and those rules are enforced. And big business isn't always the so-called perpetrator. They're sometimes the victim, and they need to have confidence in order to enter Canada, to invest in Canada, to do business in Canada, to have rules of the road that are coherent, principled, and enforced. So in terms of your question, it kind of comes embedded with an assumption that there should be more powers for the Bureau. And I'm not sure I'm entirely in agreement with that. Do I think that there is a problem? I do. I think there is under enforcement in Canada. I do believe that Canadian market structure has become, in certain sectors like airlines and banks, very oligopolistic and very comfortable with it, to the detriment of Canadians. I think that is a function of, there's smarter people than I who can speak to what it's a function of, but certainly from my perspective, it's a combination of protectionism, like, foreign ownership rules and that sort of thing, and also regulation, as well as, and I certainly don't hold this to anybody's account, but insufficient enforcement from the Bureau, but also other regulators. You know, I'm not sure the answer to our ills is to empower the commissioner with greater powers per se. That may be just a bit of an easy fix in name only. You know, consider for a moment some of the powers that the commissioner wants, and I'll just pick a couple and pick on them. Those aren't necessarily what I said is looking to promote through the consultation or indeed any proposed amendments, but they are mentioned in the consultation paper. So I pick out a couple of them and pick on a couple of them here. So the first is an independent power of decision by the commissioner. You know, that'd be just like the emperor, just like Europe, you know, thumbs up, thumbs down to a merger. No questions asked, no check on that power. You know, whatever you may think of the Rogers-Shaw merger, and I'm utterly agnostic on the point, you know, a full hearing by expert judges in the Federal Court of Appeal, and listen, everybody has frailty in their ability to predict the future, but for what it's worth, their clear decision without any real hesitation was that that was a good merger with the remedy that was involved, and that the commissioner was wrong to pursue that challenge in the face of that remedy. You know, had that prevailed, we would have stopped that merger. It would have killed it. And I'm not saying it's right. It's not saying it's wrong. It's just testing is vitally important in our tradition. You know, and our tradition in Canada is not to give absolute power to appointed officials. They need to make out their case before they get their win. And believe me, it's nothing to do with having confidence in the commissioner and the committed staff at the Bureau and their commitment to doing what's right for competition. I absolutely believe that to be the case. But it is right and healthy and consistent with the best of our Anglo-American legal traditions to require officials to make out their case before their idea of a remedy is implemented, not to just simply shut down, for example, a merger on individual fiat. You know, a second power that the Bureau seems desperately to want, and I have to question why as a former commissioner, but that's another question, is subpoena powers to collect information from market participants. And let's be clear, that's in a context where there is not even a preliminary conclusion made by or even enough to start an inquiry idea within the commissioner that there's a market failure or there's been a violation of the act, but rather just to look around, see if there might be some market failure or some distortion or potentially some violative acts happening in a particular industry. Now, I want to be clear, there's two varietals, in a sense, I would say, of these compulsory powers being exercised. One I have much less problem with than the other. The first is to assess the effectiveness of their past enforcement actions. The FTC in the United States does this a lot, and I think it's quite healthy. It's like we took some enforcement action or we didn't. Did we make the right decision? I have a lot more time for compelling information in that context, but even there, it seems to me a third party weighing in on whether now is the right time to impose that burden on business, to require them to answer extensive interrogatories, to potentially be drawn up, you know, for giving testimony. I'm not sure that that should be without check. But it certainly is a lot less offensive to me than the second, which is, again, perhaps well-intentioned, but you know, the Bureau exists in the real world, and there is always there's always a sense that you want to be relevant. And that does make you susceptible to, if you had these powers, to start investigating an issue that's very top of mind for Canadians. So, for example, high grocery prices, inflation. I think we all know that there are better parts of our government that understand the intricacies and the complexities of the forces of inflation better than a lawyer or an economist who's heading up the Competition Bureau. So I'm not sure that's a really good use of resources, and it certainly causes a big imposition on the businesses that are affected. Likewise, and even worse, is if Parliament has the ability to throw an issue over to the Bureau to sort it out. Can you imagine a more wonderful gift on your plate if you're a politician and you have a hot issue that's getting tons of media attention, and oh my God, you just want this out of the way? Oh, we'll have the Bureau look at that and they'll study it, and then your next 6 months are good to go. That would be a colossal waste of resources for a law enforcement agency to be engaged in a fact-finding expedition that has nothing to do with a violation of the act. It's a zero-sum game, and if we want more enforcement in Canada, the exact wrong way to go about that is to enforce them to have to do market studies at political whims. That's why I question why a commissioner would want it. Because for me, I looked at my budget, small as it was, there was no way I wanted to be forced to use it to just do a bunch of studies. It's not the right role for a law enforcement agency, in my view. So, what are we trying to fix? I don't think it's that complicated. We do have under enforcement in Canada. But what do we need to try to fix that? Well, we need a well-resourced bureau. We need a driven and independent commissioner who is not beholden to anything but Parliament and is unafraid to take cases. We need a coherent Competition Act, and we need some measure of private enforcement, in my view. With the Act, with respect to resources, there's never enough, of course, but if we're going to be comparing ourselves and the effectiveness of our regime with countries that are not necessarily by many scores bigger, but have resources, many scores, what the kind of resources are that the Bureau has, well, that's just an unfair fight. And we're always going to lose in any self-examination. Secondly, we need a commission who's truly independent. And the commissioner is independent in many ways, but it's an attenuated independence. The financial wherewithal and the HR for the commissioner is very much driven by the Minister of Industry and the Deputy Minister, who work very cooperatively and well, but it's not independence. And it's not directly reporting to Parliament, reporting to Parliament rather through the Minister of Industry. To my mind, it would be healthier if the commissioner had to answer to Canadians directly in Parliament. Not necessarily a huge thing, but could be an important mind shift. And then finally, with respect to the Act and private enforcement, we would be better off if we could just toss the thing in the garbage, to be honest, but I know that's not going to happen. We've ended up with a very convoluted act with subparts to subparts to subparts and not very helpful jurisprudence around it and very little of it, for the reason that it's very hard to bring a case. So why would the Bureau bring a case when all those subparts make it very difficult to do so? I have some sympathy in that regard, but that's not going to happen. So could we clean it up a bit and get rid of some of the sludge and the mold that's grown on it? Sure, we could. But what we really absolutely do not need is to depart from principle. We do not need to make it easier in some unprincipled way for the commissioner to win cases. We shouldn't be relaxing standards just because it would make it easier to bring cases in some, again, unprincipled way. We shouldn't be bringing in per se rules, in my view, certainly not with a justification and more experience as to why what we have is not working when it's been tested, because it hasn't really been tested. Have you seen a case other than the Facebook? Again, and that really wasn't, the traditional kind of competition case in this area. So, this notion that we bring in something that would just say you're big, therefore you're bad, or you play by different rules, I have a real concern about insofar as it distorts any kind of principled anticipation, predictability, or enforcement of the law. To say that mergers would be presumptively bad just ignores the fact we all know is that many mergers, in fact, most mergers, are great drivers of productivity, of R&D, of innovation, and all the things that we have insufficient amounts of in Canada. So, in terms of where we should go, in terms of what my views are, if you were going to enhance the powers, is first make sure you don't lose sight of principle. Don't be lulled into thinking that, oh, if only we had special rules for big tech, or if only we heard from more voices, or if only we tried to address income inequality and labor distortion through the Competition Act, this would be the answer. Well, it isn't. I think, Elisa, not trying to say she's saying what I'm saying, but, as she pointed out, there are other public policy areas and there are other statutes and there are other areas where the government can go to try to address those very worthwhile concerns. To put them in the Competition Act is to court disaster. They conflict, they will inhibit the ability of the other to make any advancements. And I think it's doomed. So I say don't use the Act to make it easier. Do give the Bureau more money. Do ensure that they're independent. You've got someone courageous who's willing to lose cases. And do introduce some measure of private enforcement, which I can talk about if you're interested.
Absolutely, we're going to definitely get to that. We've got some questions coming in about competition in other forums, which we'll also get to. But we've got to ask John and then Elisa, John being the most recent commissioner, what kind of powers he thinks the Bureau should have, or if they have the right powers as is.
Well, Melanie covered the waterfront quite a bit. I agree with her in large part. We do have a fundamental disagreement on whether or not the Bureau should be involved in competition advocacy or promotion. In my mind, they're the only government institution in the country that does that function or provides that function. It's embedded in legislation. that allows the Bureau to make interventions before regulatory bodies to promote competition. Most agencies around the world have this dual function. And again, valid points Melanie's making about the need to be focused on enforcement and not get distracted. The Wilson panel review suggested creating another body in Canada to just conduct market studies and look into issues so recommendations can be made to government to remove a lot of the protections that are currently exist in our country that stop competition. Who will be promoting that but for a body that's designated to do that? Currently, the Bureau is tapped to do it. In order to do it well, you need access to company documents, I'm afraid. I think there needs to be oversight on that. I fully agree they need to be accountable, going to the tribunal like they have to do now for Section 11 orders. And again, they'll be limited by resources on how many of these studies they can do. I really think it's an important piece that's missing from the current legislation. Providing that to the Bureau, I think, is really, really important. I've also indicated better tools to deal with digital markets would include, enhanced powers of injunction using maybe a prima facie standard, and of course, use the ability to use arbitration to come up with immediate remedies, as is used in other areas in regulation. So, the Bureau could use a few more tools. I don't think it needs to become a commission, if you will, final arbiter of decisions, which can only be appealed to the courts. I think that would be a huge overstep and mistake because it's not set up to be a commission. They don't have the expertise. It would be a new dictatorship that businesses would have to live with, as Melanie intimated, with very limited abilities to, challenge the issues, but before the courts, and the courts provide deference to, a commission. That's the way they've been set up elsewhere, at least. The commission is an expert body, and there's usually deference to them. So careful giving too much powers to the Bureau. I think they have a lot right now: ability to search and seize, wiretap, subpoena powers. They got all kinds of powers. I just think they need to be able to work quicker, and they need to be independent of the department, be able to go directly to Parliament, and be accountable to Canadians.
Perfect. Before we get into the role of private enforcement, Lisa, anything on Bureau powers?
No, I don't think so. But look, I just wanted to comment. John, I don't think, I certainly didn't hear Melanie say that she didn't think there was a role for the Bureau in competition advocacy and promotion. What I heard was the Bureau doesn't need to use law enforcement powers or be given additional law enforcement powers to play the role of advocating for promotion. And she thinks the budget is better spent doing enforcement. But I think they're two different issues. I think the Bureau, the promotion branch does an excellent job in soft advocacy. It has a seat at the table. It does provide its experience and expertise. The Bureau learns a lot about markets through merger review, through its investigations where it's exercising its enforcement authority. And I think that they're two distinct issues. I also find it interesting. Like I can see where if the government is truly open to, the broader government is truly open to investigating an issue to see if there is a opportunity to increase competition by changing rules or structures, and they may want input from the government. I could see them looking to give the Bureau some additional information through market study powers, but I also see a situation where the Bureau will exercise its own independent judgment to engage in a very costly and time-consuming market study to give the government a recommendation that it's not ready to hear. And then what have we done? We spent a lot of money and a lot of time, and we're going to end up in the same spot. So, I mean, I'm so supportive of the Bureau's role in advocacy and promotion, but I stand with Melanie on the dangers of market power. And I just, John, I agree with you 100%. The language used in the consultation on giving the commissioner first instance ability to prevent certain types of conduct is very dangerous. It's counter to a free market economy, but I think there is room, as you point out, perhaps in really closely looking at Section 103 and ensuring that that injunction power isn't unduly onerous, and maybe there is some scope to change there, but not a first instance ability. That would be complete wholesale change.
Excellent. So before we go to questions, we're getting some from Larry on the efficiencies of the defense. We got to follow up on Melanie's point about private enforcement. So What do you think the role of private enforcement is to complement the role of the Competition Bureau?
Yeah, I actually, I think it's unequivocally an essential tool if we want to be serious about enforcement in Canada and having any sort of disciplinary effect. You can raise fines to the moon, but if nobody thinks they're going to get called to the mat, it really doesn't matter. There will be no discipline as a result. And the Bureau, again, not by way of criticism, but by way of just reality, even if they were 10 times bigger, they're still not going to have the ability to really probably make much of an impact in terms of enforcement uh, of the laws other than the merger laws, probably, which would continue to come to them. You know, even the U.S. You know, relies largely for its consumer protection and certainly its abuse of dominance or market or monopoly cases, they call them, on private enforcement. The reality is you have motivated businesses who are genuinely being harmed. They're not going to spend their money if they're not genuinely being harmed competitively. Now, a competitor harm is not enough. Obviously, it needs to be the competition in the market, and their lawyers are going to tell them that. But you've got actually someone who's motivated to do it. Now, in order to be motivated, there are some key critical things you need to have. You need to have the availability of damages. You need to have, I think, access. It can't be through a gatekeeper tribunal that really doesn't have any interest in sharing the load of developing the law. Maybe they do, maybe they don't on an individual basis, but as an institutional matter, they do not. And then I think, you know, one of the ways you manage it is cost consequences. You know, not to grade what happened with class actions, but if we think of when they were coming into force, I don't know, near the beginning of my career, some, you know, too many years ago to mention, Chicken Little, sky's falling in. Oh my God, we're going to be the United States. It's going to be a disaster. Well, I would say that perhaps we've developed our law in some unfortunate ways, and that, you know, it's pretty easy to get certified or to survive summary judgment in a way that it's not in the United States, actually. And we've ended up with a relatively lazy plaintiff's bar, nothing personal to anybody, but who basically just extract rents from defendants who've just been done with it everywhere else in the world and are like, I need to move on. I'm not sure that's all that helpful, but the reality is the sky did not fall in. I think we need to put some checks on any private right of action here so that we can comfort the business community that it isn't going to fall in, but I really don't think it will. Let's put some cost consequences on these cases, perhaps limit the class action availability. But, you know, at the end of the day, I am just not persuaded that it is in anybody's interest, including big business, to not have healthy functioning markets where victims can't bring cases.
So if anyone's interested in views on private rights of access to the Competition Act, the CD House Institute's been publishing a boatload of material with contrasting views on the merits of it. Any other views among our panel members on the role of private access to enforce competition?
Yes, and so look, this is one area where there's not a lot of consensus, and I think it's ripe for a lot of debate, and also I think a very detailed debate, because you know the way that you know Melanie has expressed it is at that quite high level, damages, treble damages, how do you control cost, and then access versus leave. But I think we need to get into the details, and I'm actually really looking forward to seeing how this evolves. But there seems to be we have leave right now. It's not been used that much. There may be some ways that can be not tightened but broadened, because is there an opportunity for people who are indirectly harmed to bring leave or not? Is that the right thing to do? And also, Melanie, one thing that I was sort of looking at is right now you can't have private action and commissioner action at the same time. If we're going to a private action model, that probably doesn't make sense. We need to think through how that would work. Like, you know, you're giving a certificate that the commissioner is or is not on inquiry. Well, we know the commissioner can be on inquiry for a very long time. So does that mean the private actor has to sit in the sidelines for 3 years? Like that doesn't make sense. So all that to say is I think there's a lot to talk about and dig deep on how, as Melanie says, we're going to create private access in a way that is transparent, fair, used, you know, all of these various things.
Exactly. One example of that, the private sheriff policy that was created in the budget bill of unintended consequences, and that's just one thing that we'll get into, I'm sure, on process. Yeah. John, go ahead.
Just one short comment. It's very high level. The mechanics, obviously, the lawyers are getting into. I'm just thinking, you know, if Canada's serious about increasing competition, knocking down, you know, anti-competitive behavior, having deterrence through private actions, I think would be helpful in that regard. I don't think the current regime works very well, and it could use improvement.
Yes.
Yeah, my vote would be, let's just not be classically Canadian and timid. This nonsense in the budget bill about leave to bring a case and there's no pot of gold at the end of the rainbow, who in their right mind is going to waste the resources to bring that case? They're not. I mean, there might be the odd time it is strategically tied on to another matter, but it's just not a private right of action. And let's have some courage here. Let's put our money where our mouth is. If it's a disaster, there are ways to back away. I really do think, I mean, Elisa's right. We need to think through the details, but let's not trip, let's get out of our own way and actually do something good for competition in Canada. And I think it's interesting, every single former commissioner, well, save one actually, I think, in living memory, supports some kind of real private action. I think that tells you, because it's not like we didn't like being the boss and controlling everything. It's a nice place to be, but you also are acutely aware of your limitations in terms of making a difference.
Very well said. So just as a reminder, for those who want to ask a question, please go ahead and put that into the Q&A box or the chat box, so I'll make sure to get to them. So one question that has come up that we'll get into is around the efficiency of the defense. So first of all, I'm going to ask for a volunteer to define for our audience what the efficiencies defense is, and I'm just going to randomly assign John to give the simple explanation of it. So what role do you think this plays in mergers? And what do you think it should look like going forward? And the question is also, it's not just mergers, where if efficiencies defenses change, so in such a way that that's only going to say benefit consumers and suppliers, what are the knock-on effects of some of the other parts of the act, such as abuse of dominance, that have to interact with merger policy?
Yeah, Ben. So efficiencies defense is pretty much unique to Canada. It's an exemption that allows for anti-competitive mergers to proceed. If the fixed cost savings outweigh the harmful price effects of a merger. This very narrow trade-off approach was defined and developed in the Supreme Court of Canada in Trevita. Very narrow approach, looking at fixed costs versus price effects, excluding a number of areas. It's a very narrow approach right now. Does not include non-price effects, other types of efficiencies, dynamic efficiencies. No one's even talking about them when they're presented to the Bureau, or everyone's eyes glaze over. It's a very narrow interpretation of our current legislation. Also involves a lot of speculation, because future efficiency cost savings in a merger transaction are notoriously difficult to predict, and studies have shown that most of these efficiencies that are being claimed will never come to fruition. Yet they need to be given credit in a theoretical argument before a tribunal if there's an expert who says, "Oh yeah, they will." So again, the harmful favoring of anti-competitive deals, creating more concentration in Canada at a time when we've got concerns about concentration in Canada. So having this defense, I think, is just so counterintuitive to competition law. The theory being, it's an economic theory, that, if you allow for deals that will grow the pie, the economy grows. Well, again, proving that the deal grows the pie, I think, is almost impossible, but it is a nice theoretical argument. It adopts the naive trade-off model of Williamson, who, again, called it naive for a reason. It had a ton of assumptions built in to having this approach even be considered workable, including full employment, free transfer of money, all kinds of assumptions that don't exist in the economy. Yet Canada adopted this defense. To me, it was a quid pro quo for allowing merger control in 1986 in order to support Canadian businesses so they can compete internationally. Well, again, another abysmal policy failure, that none of the deals, contested deals, actually came to fruition that involved exports. So, we've had over 30 years of experience. We've got this bugger thy neighbor provision, I would like to call it, meaning we're quite happy to export our higher prices to the US and EU. However, if there's a deal that involves those jurisdictions and it's going to raise prices, they'll block it, just like they did in the Connexa Superior Plus deal. We approved it on efficiencies. The Americans blocked it because it was going to raise their prices. So it's a poorly constructed concept that we're going to export our high prices to other countries. That's the premise behind the efficiencies defense. I'm totally opposed to it, have been from the get-go, and have fought against it my entire career and will continue to do so. So I think we should move to a factor, considering it as a factor, because efficiencies do have some merit in a merger review and should be given some credit, but not at the expense of competition. Like, why have a competition act if you're not going to promote competition? You're going to promote monopolies. It just makes no sense. And the public is now aware of it, thanks to the Roger Shaw deal. And again, everyone's scratching their head saying, how can this provision exist in our law? We need to strengthen our law and get rid of that so we can actually challenge anti-competitive mergers with all that noise of trying to figure out how many efficiencies there are and that huge cost burden which is applied on the Bureau. Anyway, it's a very emotional issue for me. I've been dealing with it for years. And so I do apologize for the heightened expressions here, but I just think it's bad government policy and needs to go.
Well, thank you for bringing some passion to economic analysis. Any other views on what's obviously a very controversial topic in competition policy, the efficiencies defense?
Well, unlike John, I've been on both sides of this. First, in a case we went on and were involved in for years, where efficiencies were successful in allowing a deal through for my clients. Then as commissioner, having to deal with it, having to deal with potential amendments to it, and a lot of discussion about how could we amend it. And then again, back out on the private side, recognizing that from a strategic perspective, in a very small handful of cases, it can have some benefit for you. I not nearly so passionately, but I think on balance, come to the same view as John, that, and I think I give a little more weight to the importance of efficiencies, perhaps in merger review than some. I think it is an important factor. It's not just one of many factors. I think it's a very significant factor, but not for the reasons that justify the efficiencies defense, and that we still see the old guard raising up from the, no, that's not fair, raising up just to defend what was put in as, making us national champions, and we'll be able to compete better abroad. Coddling at home don't get you true, strong competitors who can compete on the world stage. So I don't buy that for a minute. If we're talking total surplus in Canada, we'll share resources more broadly. Well, that's, again, it's in a very perfect world, which is not the world any of us live in. So I think it should be a very important factor. I think we should consider seriously. It's ironic because the US is debating and hotly departing from a long standard of consumer welfare, but a net consumer welfare standard of some sort, which would basically mean we take them into very serious consideration, efficiencies, but there has to be some way in which they are passed on. They're not just simply enjoyed by the shareholders of the merging companies. That with some way to preserve the importance of efficiencies, because I think it is important, and not go to Europe where it's almost a negative if you say your deal has efficiencies because they immediately get suspicious. We got to stay where we recognize that's not the way to look at it, but perhaps depart from this notion it's a defense. I don't think that is the reason that the Bureau has been unsuccessful in challenging cases. I think they have not necessarily accepted that they have to deal with efficiencies. They're there until they're not there. And that may have been some of the problems that they've encountered in terms of trying to stop deals. But, if we had an efficient judicial, and I don't know that it has to be the competition tribunal, if we had an efficient, very speedy resolution, I'd be much more comfortable with a TRO, like in the United States. They have a temporary injunction, it's very easy to get, but they also know they're getting to trial in 6 weeks. We have a registrar at the tribunal who's embedded with the very same lawyers day after week, and they get lulled into these extensive, now Roger Shaw was a little bit different, but generally speaking, get lulled into these extensive timeframes. So it takes forever to resolve a case. If we're into that kind of an environment, I think we've got a real problem in terms of giving any more injunctive power, which John referred to. I've merged into that because of efficiencies, because that tends to be the area where the Bureau complains the most. They say, well, we can't get injunctions because there's this efficiencies defense. I actually don't even think that's true. But I do think there could be some tolerance for an easier injunction, provided we had a better system that didn't have such the holdup that we have right now.
And I don't want to wade into efficiencies. There's many, many people who take strong views on this side of the debate, but I do think the Roger Shaw case does demonstrate, it came up twice in two different examples there, that we have the institutions that can work in a very, very quick speed. So maybe Melanie, as you say, there are ways to work around there to adopt some certainty like they have in the US quickly, but I think they've demonstrated they can do it. They were very, very committed. I think it also demonstrates that, you know, we need to be careful as we're examining these issues. I mean, Roger Shaw was not about efficiency. Sorry, John. It didn't
Well,
come.
actually, I worked on the file. I have to admit my conflict. And if you look at the representations that were made before the tribunal, efficiency claims were made.
Yeah,
And they just never, the tribunal never had to go there.
that's what I mean. That's what I mean.
But it still brought up the prospect of an efficiency defense.
It did, and that was huge in the media, and that's where this whole debate has come up, but not on the facts of the case and the decision that was made. So my only point is, you know, when we're examining these issues, we have to make sure we're examining the issues that are, you know, current and live at the time. And there's a lot of emotion around the efficiencies defense that sometimes can color decisions at the moment. So it's just the only caution I would bring in there.
Excellent. So we got some more questions coming in. So one question that's a theme of something we discussed earlier is, what else should be in the scope for the government as part of its competition policy review? We've got Big C Competition Act review, and then there's Little C competition, where it affects the economy writ large, where you see it in the telecom sector, the banking sector, the airline sector. You list goes on, including dairy, which we may or may not get into. Are things like, you know, the CRTC and challenges there a big part, should they be a big part of this conversation, and how we tackle this? So maybe we'll go to Elisa first on this one.
Yeah, thanks, Ben. I mean, it's interesting that you know, both John and Melanie raised these as potential areas for discussion as part of this policy. If people have talked about foreign investment, airlines, competition, banking, that's come up. And I think you're seeing more and more people writing about that. So maybe this policy will be used for that. My sense is that the government was not intending that this consultation would be about competition policy writ large, but that this consultation was about competition law and policy. So in other words, the act, and maybe they are open to it. I don't have a good sense, but even if they are open to it, then even looking at tax policy and the role that tax policy plays in ensuring markets are competitive is also something that can be examined. So it's huge, and this type of policy making is highly complex. But if we don't go there, I do think it is important that we give recognition to the role that all of these issues play in defining the marketplace that the Competition Act and competition law is then required to oversee or monitor and enforce, so that expectations are not unreasonable. Like, if we're not going to all of those issues when it comes to competition policy reform, then we can't have unreasonable expectations about what a reform of the Competition Act is going to achieve.
John, Melanie, anything to add on Big C versus Small C competition?
I just think
Go ahead, Melanie.
Go ahead. I think it's a huge missed opportunity. I think Lisa's probably right. I don't know that was in their plan to look at competition policy writ large, but I think it would be sort of wild to give all sorts of new powers to just the commissioner while ignoring the elephant in the room, which are some serious impediments to competitive markets in Canada, like our foreign investment restrictions. You know, this just willingness to regulate. I mean, look at some of the bills in the House right now, not in our space, but like there is just an openness to regulate and play we know best daddy for Canadians that, you know, depending obviously on your perspective, is or is not a positive. But if you're going to bring that into competition, I have a perspective, and I think that's the wrong one. Give a bunch of powers to a commissioner and ignore the real serious policies you have that are impeding competition and competitive markets.
Yeah, and I was just going to add, Melanie, I think there needs to be some coherence here. There is overlapping jurisdictions in so many of these small C areas, you know, from telecom to privacy. Let's go down the list of the different policies, and there's overlap between the Bureau, its role, and the other agencies' roles. The privacy bill is a prime example. You know, it looks to create a digital commissioner that's going to be responsible for artificial intelligence and the competition issues therein. So what role does the Competition Bureau now play in taking on enforcement cases that may touch on AI versus what the other regulator is going to take care of? If you look to Europe, in the telecom space, many of the telecom regulators are also now being asked to regulate or oversee competition in digital markets. And of course, you still have your competition authority there. So the interplay between the existing competition authority and their powers and their responsibility versus new ones that are being given in response to an issue in a particular sector, creating this hodgepodge and a ton of overlap. And of course, it's going to be a huge burden on business, going to create a lot of confusion and ton of inefficiency. So the policymakers should keep an eye. And unfortunately, ISED is responsible for marketplace framework, has the best ability to coordinate and make sure there's some coherence in the interplay on competition issues between the Bureau and other regulators. And I just put that out as a word of caution as we're looking to policy reform in the competition space.
Perfect. So we've got time to think for probably one more question, but let's finish up with where you think this review is going and the process of review of the Competition Act review. Because last spring, the government pushed through reforms to the Competition Act through the budget bill. So what do you feel that the consequences of that were, and what lessons should the government take from that process to use this time around? John, why don't we start with you, and we'll use that also for any closing remarks that you all want to make.
Yeah, the budget implementation amendments were unfortunate in terms of the way they proceeded without minimal public consultation, criminalized wage fixing and no poach agreements, basically because of the politicization of hero pay removal by large grocers who are caught in a collective action issue. Whoever moved first was going to be punished. So because of that, we criminalized this type of conduct, which is better looked at civilly, because buy-side agreements have some pro-competitive advantages, results in lower costs for consumers. I think criminalizing that creates constitutional issues. So there's a lot of things a lot of issues if we rush into policy change like they did with the Budget Implementation Act. There are other concerns as well about the vagueness of some of the new provisions that could deter competition on its face, particularly in the abuse of dominance provision. There are some positive amendments, I thought, dealing with digital markets that will make it easier for Bureau and tribunals to get their head around digital issues and reaching a determination. But ultimately, I think it's important that this round, which I think is going to move quite quickly, because there seems to be a huge appetite for this reform amongst the politicians and amongst the Canadian public, that this process be more thoughtful, especially than the Budget Implementation Act process. That when changes are made of any significance, if you can find some studies that support the need to make these changes, that would be helpful, as opposed to relying on narrative from progressive armchair quarterbacks that have never practiced or very rarely practiced in the area, prognosticating on the changes that should be made. I think government needs to be really careful about that. And there's a lot of that armchair quarterbacking going on. In my mind, competition policy changes should not depend on, tweets in the Twitter sphere and in the online debate. I think it needs to be reasoned, well thought out. And I think the government's moving in a proper direction, having roundtables, having, submissions being made. I just hope they don't rush to judgment at the back end, that it's more thoughtful, just because of political expediency, because there is some heat on the government to do something about competition.
Elisa, Melanie, any last thoughts on what to expect from the review?
I would say, there's no lack of curiosity, good intention, right? Even say, brilliant policy minds at ISED who are asking the right questions and doing the right things. But let's not be naive. This is a political process. This is a political event. And most of the audience doesn't know an efficiencies defense or an abuse of dominance test from, a hole in the ground. So, I think it would be unfortunate indeed if we were to find ourselves in a place where either the fuzzy thinking of those armchair quarterbacks who really they want to fix, they may be very well intentioned, but public policy folks who want to cure all ills through the Competition Act, that somehow takes hold, that either that happens or that, you know, people genuinely do believe that rather than deal with problems of their own making, like these foreign investment restrictions and the inhibition of trade as between provinces, if that's something they're just, oh, we won't look over there, look over here at all the powers we're giving the commissioner in your favor, Canadians, that is doing no favor to Canadians. And that would be a hugely missed opportunity. But, you know, I'd love to be as optimistic that a good process is going to lead to a good result. I fear that we will have a good, very thoughtful, very academic, and very sound process, but that, you know, at the end of the day, you know, we have the powers that be that will make the decision, and they're going to be making a political decision.
Elisa, you get the last word of the day.
Look, I guess I'm hopeful that we can find the sort of consensus or middle ground where changes that will make the act more effective for Canadians can happen. I think this is probably the third step in that process, and the broad engagement is helpful and necessary. You know, the fourth step will be back in the offices of the bureaucrats. They'll be doing the drafting. And I think, to John and Melanie's point, you know, the fifth step should be a more precise, further, perhaps not broad consultation, but narrower consultation on the proposed amendments. For this to go BIA would be potentially very harmful, because there's difficult issues that need to be addressed, and precision will become important. So I think as long as we take this broader consultation and narrow it down to something where we can have genuine feedback on what the amendments will look like precisely, then I think we'll get, I'm hopeful we'll get to some sort of effective resolution.
Always great to end the roundtable on a hopeful word. So thank you very much to all of our speakers today. Thank you very much for those who joined us online. And as I mentioned earlier, this will be shared with all of our stakeholders shortly. For those who are able to make it on Tuesday to Toronto, if you're not busy completing your last minute RRSP contributions for February 28th, we have the Commissioner of the CRA, Bob Hamilton, speaking at a luncheon event at the CD House Institute headquarters in downtown Toronto. So with that, I'll thank everyone again for your participation today, and we are adjourned. Have a great afternoon.
Thank you, Ben. Thanks.
Bye.
Thank you.